Hey, I'm back, and I don't know how many times this is, but you can never have enough lawyers on social media, right? And let's face it, I mean, these are questions that everybody has, and hopefully these answers are helpful. So today, a little bit about non-compete agreements. I'm sure you've seen these, especially if you're in any type of sales or highly technical industry, anything where client lists matter, and technical information matters, and proprietary stuff for your company matters. So, I get asked a lot about non-competes and when do they apply and how are they enforced and that kind of thing. So, first of all, whether you are starting a new job or you've been working at some place for a while, at least in the state of Ohio, a non-compete is always enforceable from a what we call consideration standpoint. Like, what did you give up or what did the company give you in order for you to sign the non-compete? We call that consideration. Anyway, by you either taking the job or you continuing to stay on at the job, that's all the consideration that's needed for that non-compete to at least be enforceable on a base level. Then you get into whether the non-compete itself or the substance of it is actually enforceable. And courts will look at three things. They'll look at the time of the non-compete, how long is the restriction in place for. They'll look at what's called the scope of the non-compete, and then finally the geographic kind of area where the non-compete is enforced. And if you don't know what a non-compete is, one, probably doesn't matter to you, but number two, you may actually be under one that you're not even aware of. So, go through your employment package, figure out what you signed. Hopefully this time you at least read it and figure out if you are actually under a non-compete restriction. So a non-compete restriction will tell you that if you leave company ABC that you work for, that you can't compete with them anymore, or you can't compete with them in a certain time frame or in a certain geographical area. It may also have some restrictions on your ability to try to get people to leave your company and come work wherever you decide to leave and go work next. So that's called a non-solicitation. So beware of those. But what you want to look for is in most industries, what I see anyway, is that 12 to 24 months is pretty reasonable from a time period standpoint, meaning you can't compete with your old company for 1 to 2 years after you leave. What I see for the scope exception part of it, or the scope limitation, is it's got to be pretty, I don't know, pretty closely tailored to what you do. So if you work for a company and you sell metal piping for that company to oil and gas clients, well, if that non-compete says you can't work in the oil and gas industry anywhere, well, that's a little bit too broad. Or if it says you can't work in any type of sales job, that's also too broad. So what you're looking for when it comes to scope is a non-compete that says, hey, you will not work in the metal piping industry where you sell piping to oil and gas companies. So that's a pretty narrow scope, but that's probably enforceable versus some of those broader ones which say, like I said, you won't work anywhere in the sales industry or anywhere in the oil and gas industry. And then the third one is geographical scope. So let's go back to that example. If you work selling metal piping in the oil and gas industry, but you only work in the Midwest region, then your non-compete could cover the whole Midwest region, but probably won't cover California or Texas or something like that, or other parts of the world. So that's probably an enforceable restriction because that is a geographical scope that is, reasonable. But if your non-compete says you won't sell metal piping in the oil and gas industry anywhere in the world, and for your job you only work in the Midwest region, well, that's probably not enforceable. So what happens, right? You leave your company, you go out there, you find a different opportunity, and maybe it's in a similar industry, but it's a different part of the country. But you get this nasty letter from your old company saying, look, you're under a non-compete, you're violating it, we're going to sue you, you better stop. So what happens? Well, first of all, I would take that letter and a copy of your non-compete to a lawyer. Get somebody to look at it, give you an opinion on whether the scope is reasonable, the time duration is reasonable, and the geographic limitation is reasonable. Number two, if you're violating that non-compete, then you really want to reevaluate the choice you made and maybe try to make a different choice. Because at that point, now you're at risk at your old employer filing for what we call an emergency restraining order, to have you, to ask the court to prevent you from continuing to work. And those are nasty. They take a long. They don't take a long time. I mean, they happen pretty quickly. And usually, you have a hearing within 14 days or so, 2 weeks after it's filed for. I mean, it happens pretty fast and furious. You need to be represented by an attorney if that happens to you. So just be aware of that. You don't want to be in litigation. Nobody wins in litigation. So hopefully, when you talk to an attorney, they'll tell you that how it applies to you is not enforceable, and then you can decide whether or not you want to fight it, because you may win. So the last couple of pieces of advice I give you: if you do leave your company and you go on to a new opportunity, even if you're not under a non-compete, I think that this is probably good, at least some good thoughts for you, just to hopefully avoid being sued. Number one, don't take, confidential proprietary information. Don't take that with it. Don't use it at your new employer. Number two, don't reach out to former coworkers and try to get them to come over to your new business. Number three, don't reach out to old clients and get them to try to leave your old company, come to your new company. Those are kind of the things that are going to end up with you getting sued, and that's what you want to avoid. So hopefully that's helpful. It's a few minutes. It's a little bit longer than I usually like to go for, but it's a few minutes on non-compete agreements. And like I said, we see those a lot out here in kind of the sales industries, the highly technical industries, and hopefully it's something that, you can avoid. And if you are under a non-compete and you find yourself with the restrictions that are reasonable, then I would definitely encourage you to try to respect that and keep yourself from getting hit with some sort of restraining order or lawsuit, whatever the case may be. So hopefully that's helpful, and good luck. Thanks. Bye.